The Rules Committee will come to order. We're here for consideration of H.R. 5, the Help Efficient, Accessible, Low-Cost, Timely Health Care Act. HEALTH is the acronym. And we are going to begin with a panel. We have one member of the panel here, so we'll begin with him, the sponsor of the bill representing the Energy and Commerce Committee. We're expecting Messrs. Franks, Nadler, and Waxman to join Mr. Gingrey at the table. So welcome back to the Rules Committee, and without objection, the prepared statement that you have will appear in the record in its entirety, and we would welcome your summary.
Mr. Chairman, thank you. Mr. McGovern, members of the Rules Committee, thank you for letting me appear before you, and I will submit my written testimony for the record, and basically tell you that I'm here in favor of medical liability tort reform. H.R. 5 is the bill. We know, of course, it's combined with the repeal of IPAB. I will not speak to that issue, but let me just say that as a practicing physician for 31 years before becoming a member of Congress,
table, Mr. Franks.
About 10 years ago, I had the opportunity, of course,
to... Please join us here at the table. Excuse me for interrupting, Phil, but I don't know that all these members know that they're part of a very powerful panel that you're now leading. Mr. Franks was going to lead it, but since Mr. Gingrey was here, we decided to proceed. I hope you don't rhyme. I know I did the right thing, so thank you for reminding me of that. And we're expecting Mr. Waxman to join you as well, so sorry.
Mr. Chairman, I'll start again then, and I thank you.
Oh, you don't need to start again.
On behalf of medical liability tort reform, H.R. 5, which is part of this bill, as a practicing physician for 31 years, I think that I know of what I speak in regard to this issue and what changes need to be made to give a more fair and balanced approach for the patients. We're not talking about for the providers here. We're talking about for the patients, because what's happening in so many states now is an award is rendered based on an injury that's sustained by a plaintiff because a provider or providers or healthcare facility has practiced below the standard of care, and a significant injury has occurred that in many cases lasts a lifetime. And these people deserve just compensation. Part of this reform legislation would address contingency fees of trial attorneys. I don't consider that the most important aspect of this legislation, though. The most important aspect is so-called compensation for non-economic, so-called pain and suffering, something that really can't be measured. And this is the issue that was addressed over 35 years ago in the state of California. I've heard it said by someone very wise that we have a Statue of Liberty on the East Coast. We ought to have a Statue of Responsibility on the West Coast. But be that as it may, I think California got it right in this instance back in 1978 when they passed the Medical Injury Compensation Reform Act, known as MICRA. Since that time, Mr. Chairman and members, the market for medical liability insurance in the state of California, our largest, most populous state, has stabilized, and there is no longer a crisis of lack of physicians, especially specialists who practice in such high-risk areas like neurosurgery and obstetrics and gynecology. Orthopedic surgery is another one where the states that have not addressed this issue are seeing more and more of their medical communities fleeing to other states that maybe have addressed it, states such as Texas and Florida in subsequent years, and even my own state of Georgia. But this is a situation where I think that the American people need a fair and balanced approach. I don't think you will find any physician in this country, indeed any physician member of this body or in either chamber, on either side of the aisle, that would say that they don't think patients should have a redress of their grievances and an opportunity to have their day in court and to be compensated fairly. But what we want to try to end is this lottery mentality whereby there may be nebulous or minimal, if any, economic injury, and yet suits go to court, frivolous suits, and in many cases juries will award pain and suffering judgment in the millions of dollars, which is in no way appropriate to the causation or the facts. So that's the most important thing. There are a few other sections in the bill. Mr. Chairman, it's very similar to the law that was passed in California, as I say, 35 years ago. There's a little difference. There was a provision in the bill that went to the Judiciary Committee, and that had to do with a collateral source disclosure. There were members of the Judiciary Committee on both sides of the aisle that were concerned with that. That basically means to let the jury know that the plaintiff may have health insurance that covered subsequent medical care, or that the plaintiff may have disability insurance that covered subsequent loss of income, and that was stricken from the bill. But the other provisions are pretty much identical. It's a $250,000 cap on non-economic damages, and some states have addressed that subsequent to the California law 35 years ago, and they have higher caps, $350,000, $500,000. In some instances, if there are multiple plaintiffs, multiple defendants, that cap could be 3 times $500,000. So states have dealt with it, and that's why in this law, this bill on tort reform, we have something called flexi caps. So if the state has already addressed the issue, then state law prevails. The federal law in that case would not preempt. So I'm going to stop at that point, Mr. Chairman. I think that gives the members pretty much a summary of what's in the bill.
Thank you very much. Thanks for your diligence and hard work on this important issue. Now we're happy to recognize the chairman of the Constitution Subcommittee, Mr. Franks. And as I said to Mr. Gingrey, any prepared statement that you have will appear in the record its entirety, and we'd welcome your summary, and we'll do the same for Mr. Nadler. And if Mr. Waxman comes in to join us, we'll proceed likewise.
All right. Well, thank you, Mr. Chairman. Mr. Chairman, in 1986, President Reagan formed a task force to study the country's tort liability crisis. Its final report concluded that tort law appears to be a major cause of the insurance availability and affordability crisis, which the federal government can and should address in a variety of ways, unquote. The task force recommended federal tort reform legislation to address, among other things, limited non-economic damages, creating a fair share rule so that defendants would only have to pay for the portion of the damages that they were responsible for in the first place, allowing for periodic payments for future damages and placing limits on attorneys' fees. All these reforms are contained in H.R. 5. President Reagan's task force pushed for these federal reforms because they realized that only a national solution could truly solve this crisis. And they understood that the Commerce Clause authorized such reforms because numerous and conflicting state tort laws have erected barriers to trade and interrupted the free flow of commerce, which is what our Commerce Clause is about. Unfortunately, 26 years after President Reagan's task force concluded America's tort system was in serious need of reform, at the federal level, little has been done to address that crisis. In no area is the problem more pronounced than America's broken medical liability system. Medical lawsuit abuse has led to increased health care costs, unfair and unequal awards for victims of medical malpractice, and reduced access to medical and health care for all Americans. Frivolous lawsuits drive physicians out of the practice of medicine in the primes of their careers. They push others away from high-risk medical specialties and cause the vast majority of healthcare providers to practice defensive medicine. Defensive medicine occurs when doctors order unnecessary tests and procedures not to ensure the health of the patient, but out of fear of malpractice liability. A recent study in the Archives of Internal Medicine revealed that 91% of doctors practice defensive medicine. Additionally, a report of the Massachusetts Medical Society found that 28% of tests, procedures, referrals, and consultations, and 13% of hospitalizations were ordered for defensive reasons. The cost of defensive medicine is a staggering issue, Mr. Chairman. According to the Department of Health and Human Services, the cost of defensive medicine is estimated to be between $70 and $126 billion per year. Out-of-control medical liability litigation also increases the cost of health care by escalating medical liability insurance premiums. It is estimated that medical liability premiums have climbed 2,000% since 1975. That's 4 times the rate of inflation. Higher medical liability premiums lead to increased costs throughout the healthcare system and reduced access to medical services. The Nonpartisan Congressional Budget Office has determined that the Health Act will address these problems. According to CBO, H.R. 5 will, quote, lower costs for health care directly by lowering premiums for medical liability insurance and indirectly by reducing the use of health care services prescribed by providers when faced with less pressure from potential malpractice suits. Those reductions in costs would in turn lower spending in the federal health care programs and lower private health care insurance premiums. CBO estimates that the savings to the federal government alone will be more than $45 billion over the next 10 years. Mr. Chairman, our medical liability system is supposed to protect and compensate victims of malpractice and improve the quality of health care. However, it has become a costly, time-consuming, unjust, and widely inconsistent system of jackpot justice, a system in which 64% of all cases are withdrawn, dropped, or dismissed as being without merit, and a mere 0.8% of cases result in a verdict for the plaintiff. And even when a patient does eventually win, they usually receive less than 50% of the amount awarded, as most of the compensation goes to patients' lawyers and court costs. Mr. Chairman, we're paying for a system in which the profits of personal injury lawyers take precedence over patient care. And I would just urge the Rules Committee here to adopt and report an appropriate rule for consideration of the Health Act on the House floor. H.R. 5 will lower medical liability insurance rates, reduce health care costs, eliminate the exodus of physicians from high-risk states, and protect patient access to high-quality health care. And thank you for your indulgence, Mr. Chairman.
Franks. Appreciate your hard work. Mr. Nadler.
Thank you, Mr. Chairman and members of the committee. I'm here today on behalf of the Judiciary Committee Democrats to urge that the Rules Committee report an open rule for H.R. 5 to allow the full consideration of many important issues raised by this deeply flawed and deceptively named legislation. Contrary to the bill's title, it will not promote access to better health care, nor will it make health care more affordable. If the wishes of many of the proponents of this legislation come true, and the Affordable Health Care Act is repealed, and Medicare and Medicaid, as we know them, are curtailed or eliminated, then decent, affordable health care will remain out of reach, will become out of reach, for millions of Americans, including many who now have access to health care services. I urge everyone to keep one important fact in mind as we debate this bill. It would apply only to people who had meritorious claims of damage. You don't have to limit recovery or attorney's fees for people without meritorious claims. So whatever you are doing here will be done to those who have been injured, whose injury has been inflicted by someone else's wrongdoing, and who needs and should be entitled to compensation. The argument, which is not a new one, is that if we allow players in the healthcare industry, including Big Pharma, the manufacturers of defective medical devices, and even big insurance companies that routinely refuse to pay for necessary healthcare services, if we allow them to escape the consequences of the harm they inflict, then somehow we'll all be better off and costs will be lower. This is not true, has never been true, and despite the extravagant claims of the proponents of this bill and the industry's lobbying for it, that will not be true if this multi-billion-dollar gift to bad actors in the healthcare industry were to become law. Just how pricey a gift to industry are we talking about? According to CBO, in a letter to Chairman Dreyer dated yesterday that's already been referred to, $45.5 billion over the next decade. Now, anyone who believes that these kinds of savings will be passed along directly to consumers, healthcare providers, and victims of medical malpractice is living in a dream world. And I will remind the members that we had here a number of years ago a debate that lasted for 8 years and resulted in the Bankruptcy Reform Act of 2005, in which we were told that if we got rid of all these spurious bankruptcies and we really cracked down on it, it would mean a $400 savings in lower interest costs to every single individual who had a bank account. Needless to say, we never saw any of those. Nothing was passed through to the consumer. CBO's letter goes on to say, H.R. 5, and this is a direct quote, H.R. 5 contains several mandates in the private sector, including caps on damages and on attorney's fees, the statute of limitations, and the fair share rule. The cost of those mandates would exceed the threshold established in UMRA for private sector mandates in 4 of the first 5 years in which the mandates were effective. So keep in mind, Just who will be bearing the burden of this legislation? People who are subject to limitations on damages, their ability to obtain competent counsel, something not imposed on insurance companies, HMOs, or drug companies. That may make the insurance companies, the manufacturers of defective medical devices, and all the other wrongdoers happy, but will come at the expense of their victims. How are these projected savings achieved? In its report to the Judiciary Committee, CBO stated that enacting H.R. 5 would reduce national health spending by about 0.4%. That figure comprises a direct reduction in spending for medical liability premiums and an additional indirect reduction from slightly less utilization of healthcare services. Close quote. Nor does CBO explain why it believes that insurance companies, big pharma, medical device manufacturers, and other players will pass any savings along to the consumers. As we saw in the bankruptcy situation, the insurance companies did not pass any of the, or the banks passed none of the savings on to the consumers. Nor does it account for the cost of the care needed by people who have been injured and who will be unable to receive adequate compensation. Perhaps we now live in a world where these entities have suddenly become public-spirited and won't pocket the savings. Perhaps the Easter Bunny will show up to testify in the next panel. Now, there are some critical issues that the House should have the opportunity to consider. I've been advised that due to the so-called Cutco rule, amendments dealing with these issues will be ruled out of order. These include Amendment Number 6, offered by the gentleman from Georgia, Mr. Johnson, which would protect state constitutions from federal preemption by the bill. I would have thought that given the superheated rhetoric about states' rights we hear from the majority, we could at least expect that this amendment be made in order. I have submitted an Amendment Number 18 that would narrow this bill to protect only individual health care service providers, doctors and other licensed health care professionals. It would exclude large corporations, insurance companies, medical device manufacturers, HMOs, and pharmaceutical giants. It is one thing to want to limit the liability of people who practice medicine to prevent them from leaving the state, but it is quite another to shield huge corporations, including foreign corporations. Amendment Number 2, submitted by the gentleman from Tennessee, Mr. Cohen, would exempt from damage limitations any health care lawsuits based on leaving a foreign object inside a patient or performing a procedure on the wrong patient or the wrong body part. Mr. Cohen raises a critical issue because actual damages, when, say, removing the wrong body part, say, removing a woman's uterus, the actual monetary damages are not very substantial, but the harm to her family, and to her future generations may require compensation beyond the minimal non-economic damages available under this bill. One would hope that any member who has ever used the term pro-life in a campaign ad would support this amendment. Amendment Number 3, submitted by the gentleman from Florida, Mr. Deutsch, would exempt from the coverage of the bill intentional acts unrelated to medical malpractice, including crimes like sexual assault of a patient. I would hope this one might not be controversial. Due to the CBO estimates, which I continue to maintain are flawed, many of these amendments would require a waiver of points of order under Cutco. This committee has seen fit to grant these waivers whenever it has served the majority's interest. In this Congress, rules waiving Cutco have been reported for the following bills, amendments, and conference reports. I will submit this. It's a whole list of bills, amendments, and conference reports for which this committee recommended that Cutco rules be waived. Given the gravity of the issues raised by this legislation and the controversial nature of the scoring by CBO in this case, I believe the House deserves the opportunity to consider these critical issues and work its will. Before we strip the rights of people who have been harmed, and again, those are the only people to whom this bill would apply, people who have been harmed by the wrongdoing of others, I think we have an obligation to consider these crucial questions. I don't agree with all the amendments submitted, but I believe that a robust and open debate is what the situation calls for. So I urge the committee to report an open rule, and I further urge the committee to waive Cutco for the amendments it makes in order to enable the House to have a full debate of all the important issues. And if the committee cannot vote in open rule, I urge it to make in order at least the amendments that I've mentioned.
Thank you very much.
Deserve no less, and I
we
thank
appreciate
you.
it. Thanks to all of you for being here. Your positions are very clear, and I will say to Mr. Nadler, we do hope very much to have an open and free-flowing debate. We've had 17 amendments that were submitted to us. I think one may have been withdrawn, and so we're going to look carefully at those, and those that do comply with the rules, we are hoping that we will be able to make as many of those in order as possible. So I do appreciate your request there. I have no question. Ms. Fox.
Thank you, Mr. Chairman. I don't have any questions either. I just want to say that I think it's important that we move forward with this. We are very concerned about the impact of the legislation that was passed 2 years ago on health care to everyone in this country. but particularly in light of the IPAB. And I think I appreciate Mr. Gingrey saying that California got it right many years ago, and I think this issue of medical liability needs to be dealt with, and I appreciate them bringing the bill to us.
Thank you. First of all, Mr. Chairman, I'd like to ask unanimous consent to insert in the record the statement by Representative Henry A. Waxman.
Without objection, Mr. Waxman.
And let me ask Mr. Gingrey and Mr. Franks, do you support an open rule for this bill?
Mr. McGovern, I don't take a position on that. It's up to the committee.
You used
When I
to.
served on this committee,
Yeah.
I was very much for open rules and as many as we possibly could deal with. So I haven't really changed my position on that.
Mr. Franks, do you have an opinion on whether there should be an open rule?
Sir, I'll tell you, I think that given the history of this institution, the Rules Committee is the best one to make that decision. In general, I prefer not always an open rule, but something that gives a fair and honest debate and lets both sides have a chance to give it.
The times, how they have changed.
They have changed greatly, with
Yeah.
all due respect, Mr. McGovern.
They
In
have.
the last Congress, we had very little chance to amend anything.
Well, they have changed. What a different tune people have now. Let me ask you, kind of the guts of this bill is the IPAP provision, but it looks like no one's here to testify on that provision, which I think is interesting because, I think what we're doing here today is a colossal waste of time. My friends on the other side of the aisle, we began the Congress by repealing outright the entire health care bill. So we've already done this in the House, and yet we're going to do it again. Why? I don't know. I guess I do know because I guess the Supreme Court is taking this up next week, and so this all kind of falls into a nice, neat package, because it's a political election year. But on the medical malpractice stuff, I'm kind of surprised that my friends who continually argue in favor of states' rights are pushing here an unprecedented power grab by the federal government. This is a direct attack on states' rights. It will require almost every state in the union to adopt entirely new rules or procedures for cases involving medical malpractice, product liability, health insurance, and just about everything else involving a medical practitioner. And I guess maybe you think the federal government knows best. And I'm just kind of surprised that this is coming out of the Republican majority. Mr. Nadler.
Yes, thank you. I just want to comment. I would suggested nothing about IPAB because I'm representing the Judiciary Democrats. I'm opposed to the repeal of that. But let me just say one thing that no one mentions, and Mr. Gingrey talked about MICRA. MICRA in 1976 put a $250,000 limit on pain and suffering. And maybe people think that's a reasonable amount. It's difficult to quantify and so forth and so on. And obviously, some things are worth a lot of money, or ought to be. But that was 1976. There was no inflator. If $250,000 was the equivalent of 1976, today it's the equivalent of $38,000 in 1978. And in the proposal in this bill, there's also no inflation adjustment, which means if it should pass, God forbid, then people will be limited, people who may suffer severe injury for pain and suffering, loss of fertility, loss of diet, children, which has very little monetary value, economic value, but big pain and suffering value. They'll be limited to $250,000 now. But 10 years from now, they'll be limited to $100,000. And 20 years from now, to $50,000, and eventually to virtually zero. There's something very wrong with that.
Can I respond to, if the gentleman would yield to me? Sure. Make it very clear that the provision in this bill, the $250,000, is a floor. It's not a ceiling. And we recognize the fact that it's been 35 years in states, Texas, Florida, Georgia, others that have dealt with this, the multiple, the amount, the cap, $350,000 per defendant, up to 3, sometimes $500,000. So the bill very specifically has a provision called flexi cap regarding those states that have addressed this issue, So federal law does not preempt whatever cap they set. They might want to put a cap of $1 million and have it apply to as many defendants as are in the lawsuit.
But when a state does not set a cap,
Right.
this would set a permanent federal cap of $250,000. Now, not on this bill, but on the earlier Med-Mal bill in committee, I suggested amendments to set an inflation. Say, all right, you're going to do 250, inflate it so it stays at 250 or the equivalent of 250 in the future. That was voted down. If you don't do that, eventually the payment suffering is going to be virtually zero.
And I'm not a lawyer, and Judge Hastings probably have more questions than I do, but I mean, states have always been left alone to make their own rules for their own courts systems. There should be no exception in this case. Medical malpractice cases are almost always limited to state courts with an in-state plaintiff and an in-state physician. And you know, and I mean, it just, I have a little bit of whiplash here from the party that tells us that the federal government should stay out of states' business, and yet in this case is inserting itself in the states' business. And I'll just say one other thing. You know, this repeal of IPAB, which is not only redundant because we've already seen this movie before. You brought this up in the very beginning, but I find it kind of astonishing that you know, on the day that the Ryan budget is released, which you know, the biggest cuts come from health care programs. He eliminates $1.5 trillion that the Affordable Care Act uses to purchase health insurance for 30 million Americans. Then he cuts Medicaid and related health programs by $770 billion, which is to say by about a third. Medicare takes a $200 billion in cuts on top of that. I mean, you know, what we should be, you know, if you want to talk about preserving people's health care, we ought to talk about defeating the Ryan budget before it goes to the floor, because it would devastate the quality of health care and the ability for people to access health care in this country. And again, with all the things that we should be doing here, millions of people don't have work, and our economy is still struggling, that we're doing these message pieces because it fits into an election year, strategy. I think we could use this time doing better things, quite frankly.
Bishop.
Mr. Chairman, I'd like to ask the three of you gentlemen, do you think that this measure is going to pass the United States Senate as it is offered? Mr. Gingrich?
Well, Mr. Tasty, my former colleague, I feel...
Just a yes or no. I understand how difficult it is to do that.
Hope springs eternal, and I'm an optimist, and I think it's possible.
Mr. Nadler, do you think it's going to pass the United States
Not in
Senate?
this Congress.
Mr. Franks?
Mr. Chairman, Mr. Hastings, I do not think it will pass the U.S. Senate. I think it's a tragedy. I think the U.S. Senate has left 32 bills to support job creation in this country, left untouched. They won't pass a budget. They won't do anything that gives this country a chance to hear. So, no, I think they will not pass it, but that does not remove our responsibility for doing our part here.
I understand. Clearly, we have that responsibility, but at the same time, it demonstrates how the lack of bipartisan effort and bicameral effort is undertaken. While we have this exacting responsibility, at the very same time, all of us know that it's dead on arrival at the Senate. And Mr. Gingrich can talk about hope springing eternal if he wants to. He knows good and well that this matter is not going to go anywhere.
Well, I keep thinking and hoping that they'll pass a budget in the Senate.
I feel very strongly. There are fewer persons that are critics than am I of the United States Senate under the control of Republicans and Democrats. Somehow or another, their arcane rules allow for things that are not allowed for here, but at the very same time, under Democrats and Republicans, measures have passed out of the House of Representatives that made an awful lot of sense that went nowhere. Mr. Chairman, I'd like to offer and ask unanimous consent for a statement of Mr. Levin to be placed into the record. In addition, Mr. Chairman, I'd like to ask unanimous consent for my statement in support of an amendment that I have be offered into the record, and I won't testify regarding it. Yes, I will. I know that'll help, Chairman. I do have these questions. I have a real concern about patients' rights, as I'm sure all of you do. But how was the cap of $250,000 determined? I mean, was it just arbitrary, or did we use a barometer of quantifying which states had different caps? How did we come to the conclusion that $250,000 is the right figure for non-economic damages?
Mr. Hastings, I can't tell you exactly how we arrived at that amount back in 1978, but I can tell you this, 35 years later, it's working in California, and even though we've raised the cap in Texas and Florida, your state and Georgia, it works. Now, I'm not saying that 250, it may have been the correct cap in 1978, maybe, depending on your state, the correct cap is $1 million. But there needs to be some certainty. It can't be a gazillion. It cannot be infinity. And that's what this is all about.
Yes, Mr. Chairman.
Well, I would point out that $250,000 arrived at, if it was the appropriate figure in 1976, would be about $1.4 million in today's money. And obviously, they can't both be the appropriate figure. What has happened in California, what's happened in other states, and what would happen if we don't change this bill is that the appropriate amount keeps going down and down and down, eventually to virtually zero. In California today...
Am I correct, Mr. Nadler, just to interrupt you for a moment, that if we are placing a $250,000 non-economic damages, that we're leaving economic damages uncapped?
Yes.
Okay, is that correct, Mr. Gingrich?
Mr. Hastings, absolutely, that is correct. You want to allow me just a second. I just want to tell you, in California, in the decade 1980 to 1989, there were 163 cases, a judgment over $1 million. That went up to 297 cases the next decade, and then 2000 2009, 330 cases over $1 million, tripled. The amount of awards, economic awards in California, I can give you a few: 12 million, 96 million, 16 million, 11,700,000. So because there is a cap on non-economic, what has happened in California, obviously, is we've eliminated all the frivolous lawsuits, and the ones that really need to be adjudicated where someone was just truly injured in a serious case, they got justly compensated.
And justly compensated more than $250,000?
Well, I would say that absolutely $96,400,000 worth of economic recovery on July 2007 in Los Angeles County.
The argument is that caused problems if we were to extrapolate that nationwide, that the handful, and you just gave us a handful, 163, 297, 330, and it may very well be that a nominal amount of those or a small amount of those did not have the kind of concern that you have. Let me tell you, Phil, where I come from on this. First off, I don't think you, me, or anybody here in the United States Congress can assess what a leg means to somebody, what an eye means to somebody, what the circumstances are when people lose their consanguinity, or however you wish to put it, when folk have their mental anguish from injuries that they receive. And that's why juries, that's why tort law has existed for all these years. And any way you cut it, your measure is getting ready to interfere with years of tort law, whether it's joint and several liability, whether it's your cap. And I don't understand how you justify that. It's okay for us to sit around in rooms like this and for us to talk about damages, but when you have been damaged, and you didn't, as a physician, doubtless do any harm along the way, but I, as a lawyer, do know that there are physicians that did do harm. They were drunk when they went in the operating rooms. They had overworked themselves and cut off the wrong leg. And you can't sit here and tell me that we ought to have $250,000 is what a cap ought to be. My leg means more to me than $250,000, and I'll bet you yours does too.
Mr. Hastings, if you'll allow me to comment.
Of course.
You're always very eloquent, and I certainly, you tug at my heartstrings, but when you look at this bill, when you realize that the punitive damages in some of these cases that you enumerated can be twice the economic damage. If you had a situation like that, in this case in Los Angeles County in 2007, the $96 million worth of economic damages, I don't know whether that was a lost leg or wrong kidney transplant or whatever, but if somebody came in the operating room drunk or did something deliberate, that's where punitive damages come in. In this law, this federal law would allow up to 2 times that amount. So, $1 billion worth of punitive damages.
I could ask the gentleman, hold on, Mr. Knapp. Do you consider this matter will stand the test of constitutionality referencing the 10th Amendment?
I absolutely believe that it will, and if you will allow me, if I can put my hand on it, there's an article that was written, and I've got one real quick paragraph in regard to that question, because I think this is a very important question. This paper was written by Paul Taylor, the Chief Counsel of the Subcommittee on the Constitution of the House Judiciary Committee. Paul is a Yale undergraduate, and he got his law school degree from Harvard. Here's what he says in conclusion. The authors of the Federalist Papers, considered to be the most authoritative exposition on the Constitution, advocated for a commerce clause that Congress could use to remove state barriers to trade that weaken the national economy. The examples they gave illustrating the need for the Commerce Clause encompassed by their logic some federal tort reforms regarding both state products and personal liability law, insofar as such reforms are required to counteract significant negative impacts on a market-free enterprise system.
I don't want to stop you, but I'd ask, please.
No, I understand.
Let me ask a personal consideration. I have an amendment that's due on the floor. I'd like to reserve, if there are additional questions when I return, I'd like to reserve the right to ask additional questions.
Well, I mean, I don't know if you're not going to run the floor,
If they don't, then they don't. But if they are here, then I'd like to ask additional questions. It's either that or I'm going to aggravate you during the rule time, so either way we cut it.
Mr. Woodall.
And I thank my friend from Georgia for bringing this bill to the floor. You know, we're real fortunate in Georgia to have so many docs represented in Congress. And when it comes to issues like this, folks don't know who to trust. We've got the Yale graduates and the Harvard graduates, and I give those folks their due for that work. We've got the University of Georgia graduates like myself who have done some good work too. But I appreciate everything you've put into that. Mr. Gingrich, I wanted to ask about the savings, and Mr. Nadler had mentioned that, you know, what were the chances that we were going to have some savings? These were actually going to go back into the.
What were the chances that we would be passed on?
Absolutely. I tell you what, that is always on my mind. I happen to believe in the free market and always hope the free market works its will. I tell my good friends from Coca-Cola that if they try to put a Coca-Cola product for $1.50 next to a Pepsi machine that's only charging $1, it's probably not going to work out well, even though Coke's a superior product, because the free market works its will.
Not Mr. Chairman, I say that I've already found something that can agree on. Coke is a superior product.
I thank you. I thank the gentleman.
I might. I'm crazy.
Though as I read the letter that you referenced from the Congressional Budget Office, I'm struck by the table that they include, and they break out those $45 billion in savings. They say we're going to save in the medical malpractice title in direct spending outlays $41 billion. So while I share your concerns about how the insurance companies will react and the docs, the hospitals, and on and on and on, $41 billion of the $45 billion that the CBO references in savings, those are absolutely going back to the American people, aren't they? Because this is direct spending that the federal government was making yesterday and isn't going to make today. I mean, this is $41 billion in deficit reduction. This is $41 billion in debt that we are not going to rack up.
Are you asking?
Yes, sir, I am.
The assumption, which I do not agree with, the CBO there, is that in fact the cost would go down, and that the insurance companies, practitioners, that everybody the federal government is paying would in fact lower their costs. There's really no evidence for that. And a similar controversy economically, when I go back to the bankruptcy debate, we never saw those savings passed on to the federal government. If you look at the rhetoric and testimony at the time, between 1997 and 2005, the federal government was going to realize great savings, individuals going to realize great savings. None of that occurred.
As much as it pains me, I have noticed the federal government tends to clamp down on provider payments as it sees fit at any time it sees fit. I know that we have the full tools that we need to reclaim those, but interesting that the CBO puts it all in that place. Dr. Gingrey, one of the things that attracted me to your bill, I'm a co-sponsor of your legislation, and I've really appreciated your leadership. I know you put in a whole Section 10 on state flexibility for and the protection of states' rights, to say that as you engaged with Mr. Hastings, that if states want to have a higher cap, if they want to have a lower cap, whatever it is that their state laws are, you're not trying to preempt those laws. You're just trying to set a standard just to make sure that states are acting in this area somewhere. Is that?
Mr. Wood, that's exactly right, and I appreciate the question. And if I understand my bill, and I think I do, states that haven't addressed this issue, after this bill becomes law, if they decide that then they will address the cap issue, and they want to put a cap of 125,000 or 1.25 million, as Mr. Nadler said, current value might be if you factored for inflation since the late 1970s when MICA was first passed. A state could do that, and that would be the law. There would not be, the federal law would not preempt that at all. They would not have to abide by the 250,000 cap.
Is the state flexibility, knowing how hard you work to put that in there, is it intentionally limited just to the amount of the award as opposed to the distribution of the award? You know, whether we're talking about contributory negligence or comparative negligence. I know there's a section in here on that. My understanding from reading the legislation is that you intended to make this state flexibility provision as large as you possibly could to ensure the maximum amount of flexibility with folks back home.
That is correct and a very good point that needs to be made, because a very important section of the bill references joint and several liability. And the situation that currently exists in most states is that in a medical malpractice suit, a plaintiff's attorney, is a smart attorney, is going to find every provider who came in touch with that patient in any way, shape, or form. Dr. Jones comes by Sunday morning while the surgeon that did the operation the day before is at church, and is just making rounds and just peeks in the door, says, "Hello, Ms. Smith, how you doing?" "I'm fine. Well, Dr. Jones will be in tomorrow." That doctor, if he happened to have most of the liability coverage, maybe the surgeon that really practiced below the standard of care had a policy worth $500,000, and the doctor that covered that day had a policy worth $5 million, then his deep pockets would be the ones, even though his liability was minimal, if any. This joint and several liability would apportion liability, and if the state had already dealt with that, then the federal law would have no application whatsoever to what the state had done in that regard.
Thank you very much. And Madam Chairwoman, I have no other questions. I very much appreciate my colleagues for being here.
Thank you very much. Mr. Polis?
Thank you. Dr. Gingrey, my question is around the constitutionality and kind of the constitutional justification. I'm a little confused by some of the arguments being made. On this bill, the justification is the Commerce Clause is providing for the constitutionality. I would ask why the constitutionality of this provision is any different than the argument being used by those who are arguing that the Affordable Care Act doesn't qualify under that constitutionality provision. If there's something regarding a national tort policy, why would that be constitutionally different as to whether it is consistent with the Commerce Clause?
Mr. Powers, I thank you for the question, and I won't try to read through this 40-page summary that was prepared by Paul Taylor, the Federalist Papers, the Commerce Clause, and federal tort reform, but I would commend it to you. And if the chairman would allow, I would love to submit this for the record, the Suffolk University Law Review. In answer to the Representative Paulus's question, how is this different? Well, first of all, in the case before the Supreme Court, as I understand it, this question of the constitutionality of an individual mandate that says to a person who is not engaged in commerce that they have to engage in commerce. It's not a question of regulating interstate commerce because these individuals are forced to participate. We've all heard the expression, the next thing you know, they'll tell us that we all have to eat broccoli. I know that's a little trite, but quite frankly, it gets to the point.
Just for a moment, however, it seems like under this tort policy, much of this occurs within a state, too. We're not talking interstate tort. We're certainly talking what can occur entirely in one state. In fact, in most instances, that would be the case with the care associated with where the person lives.
Well, it's a good point you make, but as I understand, I'm not a constitutional scholar, I'm not a lawyer, but in reading Article 1, Section 8 in regard to the Commerce Clause, and looking at case law and things that the federal government have done in the past, like in regard to the Childhood Vaccination Injury Compensation Plan, before that federal law was enacted back several years ago, drug manufacturers that produce childhood vaccines were getting, in some instances when an untoward reaction would occur, were getting sued in state court to the point that these companies were virtually going out of business. So your child, my child, our children, grandchildren would not have access to vaccinations for measles, mumps, rubella, childhood illnesses that obviously are a huge public health issue. So the federal government said that in a situation like that, that something needed to be different, and that's a perfect case where the Commerce Clause clearly applies. When you think about the situation where doctors are moving from one state to another because they can't afford to the liability of remaining in, say, Georgia, so they move to Florida, then you have a lack of access to care. That's where the federal government comes in regard to the Commerce Clause, and so I think it's very, very different from the Obama case before the Supreme Court.
And I want to go to Mr. Franco, I think, wanted to respond. But again, if a doctor moves from one state to another, that's a different state. In fact, he would then be subject to the laws of the new state rather than the old state. I think the issue is more with regards to somebody who treats and deals with residents of one state as to why there's a legitimate interstate issue. I think Mr. Frank had a comment on that.
Well, thank you. The only thing I would add to Dr. Gingrey's explanation is that in this setting, where the founders and the framers of the Commerce Clause, their objective was to create the ability for free flow of commerce between the states. And if someone goes to a medical school and then looks out and they have the opportunity to go to any state, as it were, maybe some states need a particular type of surgeon or some specialty that they might not have. Many times the tort laws and these liability malpractice laws can affect the resulting commerce that would occur here. And with the affordability or the Affordable Care Act, you notice I didn't call it Obamacare out of respect, the individual that had nothing to do with anything, they didn't go out to sue anyone, they weren't sued, they did nothing, but they're mandated to go out and buy a product. The founders of the the Constitution and those that framed the Commerce Clause did not anticipate such a thing, and that's the main distinctive between this effort and the case before the Supreme Court.
Well, like Dr. Gingrey, I'm not a constitutional scholar, but it just seems to me that the argument that you're making is that Mr. Frank made for the validity of the tort reform is the same exact argument that advocates of the constitutionality of the Affordable Care Act are making, namely that there's an interstate dimension to health care, which I agree with. Frankly, I would think that most people applying the same legal perspective would say, well, whether the Affordable Care Act or this is good or bad policy is legitimate discussion, but I think they would both be allowed in the same Commerce Clause, exactly for the reasons Mr. Frank mentioned. Doctors, patients can move. They go to medical school in one place. They may live in another. A person may be insured in one state and move to another. These are the same interstate issues which those who advocate the constitutionality of the Affordable Care Act have cited in a different setting. So, again, I think I understand the argument. I just think it's applied similarly to both. And in Mr. Frank's initial part of his remarks, had he said, for instance, the word insure instead of tort, it would have been the same exact argument for the constitutionality of the Affordable Care Act.
With all due respect, the only thing I would just reemphasize is that on the one hand, the objective of the Commerce Clause was to allow free trade, and the argument I think can be strongly made that medical liability laws in states have the effect in many cases of being barriers to that free trade. The Commerce Clause never envisioned government being able to force an individual to buy a certain product. That is not the kind of application that anyone would ever make of the Commerce Clause, which is what the case before the Supreme Court is really facing.
Well,
so I'll end there. Thank you.
Tort is a small part of overall health care costs. Obviously, there's different studies that show it's a different percentage, but nevertheless, it's not the major driver. Whether somebody's insured or not and the insurance component of the reimbursement is even bigger deal. So, I mean, if the goal is to allow interstate commerce of the Commerce Clause, surely, portability across state lines, the existence of insurance across state lines are critical components of that. So I think that the argument Mr. Frank made for the constitutionality of this is even a stronger one with regard to the insurance provisions of the Affordable Care Act. I mean, if anything, insurance is a bigger component of health care than the tort piece, which I understand is a piece of great concern. And by the way, there were provisions in the Affordable Care Act for state pilots. It took the state initiative approach. The Affordable Care Act had tort reform in it, but it left it to the traditional venue of states rather than trying to nationalize it and to have a government takeover of the tort system. With that, I'll go back.
Thank you, Mr. Polis. Mr. Nugent? Mr. Scott? Mr. Webster?
Thank you, Madam Chairman. I believe that Congress has the right to act on individuals, and however, the extent of that is being litigated now in the Supreme Court. Do they have the right to make you buy something the day you're born and keep paying for it until the day you die? And that's certainly a acting on individuals in a pretty strong way. However, I don't know of any place that there has been any precedent set where the federal government could act on states. This, and I'm going to ask a question. This, under the applicability section, says this title, regardless of the other exemptions that have been talked about, this title shall apply to any health care lawsuit brought in a federal or state court or subject to alternative dispute resolution system. So even if you don't even go to court, you just go to a hearing officer and have a dispute resolution, this law would apply to that. So my question is, do you think we really want to federalize our entire state court system?
Mr. Webster, I will point out to you that in today's medicine, of course, the telemedicine aspect of practice is would allow a doctor at Shands in Gainesville, Florida, to treat a patient in California, basically by giving a consultation over the internet in regard to interpreting an X-ray, an MRI, or an echocardiogram. So for anyone to suggest that we're not talking about interstate commerce here, and you know, I've got just reams of paper and reports, indeed even the report that was mentioned earlier that Ronald Reagan, who was really a states' rights guy, I think they called it the devolution revolution during the 8 years of his presidency in regard to an emphasis on state control. But when his commission gave him a report in regard to tort reform, the Honorable Ed Meese was on that commission and talks about that even today. President Reagan gave a speech and enumerated the things that he felt needed to be done at the federal level to stabilize the market so that we could eliminate all of this. Mr. Powell talked about the fact that the tort issue is just a small issue. I think John Kerry, Senator Kerry, got it wrong a number of years ago when he campaigned for president, when he suggested that it was, well, just the malpractice premium, that's just a small amount. That's just a drop, a spit in the ocean. What we're talking about here is the hundreds of billions of dollars a year that is wasted on defensive medicine.
Yes, I understand that, and I understand that this bill federalizes state courts in the area of tort reform dealing with medical malpractice suits. What my question was, do you think we should federalize the entire state court system?
No, I don't.
Mr. Whittle? Webster. Can I comment on this? This amendment, I mentioned the amendment by Mr. Connolly that would exempt from this bill provisions in state constitutions. This bill would specifically preempt, as far as I know, 6 constitutional provisions in states that say in their constitutional provisions there should be no caps in non-economic damages. This bill is if you believe in states' rights, this bill is a tort law has in the entire history of this country been a state matter. The federal government has never really gotten involved in tort law, as far as I know. And this bill is a massive invasion of state law, and it puts limits on what the states can do, and it even puts limits on what the state constitution can do. I do not believe that this bill is unconstitutional, as I do not believe that the Affordable Care Act is unconstitutional, and it's a similar interpretation of it's a similar interpretation of the Interstate Commerce Clause in both cases, an interpretation that has been very solid law under the Supreme Court precedent since at least 1942. Maybe this court will change that, but if you look at the precedents over the last 70 years, it's not even questionable. But clearly, this is a massive invasion of the states' rights, and if we choose to do that, we choose to do that. But don't be under any illusion that this is not a massive expansion of federal government power to tell the states what to do.
Thank you, Mr.
Mr. Webster, let me, if I could, just briefly. There are certain precedents as already put forward here by the Protection in Arms and Commerce legislation that did survive the constitutionality scrutiny of the courts. There was the vaccine and legislation, the fund that compensated people on a federal level. But the real question here is what is the reason for the Commerce Clause? Now, I understand the gentleman's concern, and I share that concern, and it becomes sort of a judgment call at some point. The Commerce Clause was put there to create an ability for free trade and for free commerce between the states, because they understood otherwise that we could all end up being, sort of a hodgepodge of different countries. And when a practice of a state becomes onerous enough to interdict that, then that's where the Commerce Clause comes into play. And I guess the question a very principled question that you've made, where the nexus of your answer would have to be is, do you think that the liability laws of different states have reached enough confusion and enough onerous effect that they are now interdicting the Commerce Clause. And I think the case can be made that they are. And it becomes a judgment call, but I do think it's good that people like you are considering the constitutional ramifications.
Mr. Webster, if I might add just briefly, because I don't think I did a very good job of answering your question the first time around, other than the correct answer, which was no. H.R. 5 does not federalize state court, nor should it. The states still control their own court system. But what this bill does is it just sets reasonable limits on court awards as they ultimately impact all of us and impact commerce. But in no way, shape, or form are we telling Superior Court judges in the states across this country how to conduct their court system.
Mr. Webster, any other comments? Well, I want to thank the panel members for being here. You all have heard the bell. The votes are beginning, but we're going to invite all the other members who are here who have offered amendments to come up or who were on the agenda to speak, and we'll do our best to let members ask their questions quickly and, if at all possible, be able to finish the hearing portion before people have to go down and vote. So if you would come forward to the table. We'll do, you're right. Sure. Thank you. I'm going to do my best. I hope that I noted who was here as you came in, and we'll try to do it in that order. But I would say to you, as Chairman Dreyer always says, don't feel you have to read your statement. Your statement will be put into the record as you submit it. If you would like to summarize very quickly your point of view, and I'm not sure how many amendments are going to be made in order, but certainly your statement does not need to be read, and I would encourage you to make your comments and leave some time for the members of the committee to ask you questions. Let me start. I believe, Mr. Johnson, you were here first, and then Mr. Brown was second, then Ms. Waters, and Ms. Lee, Jackson Lee, Ms. Schultz, and Mr. Deutsch. I hope I have that right, and Mr. Gosar. I want to be as fair as possible. So, Mr. Johnson, you're first.
Thank you, Madam Chairwoman. H.R. 5, the so-called Protecting Access to Health Care Act, is not only an unnecessary, but it's a harmful bill to the health and safety of Americans all across this country. This is the same old tort reform proposal that has been considered on the House floor many times. This time, however, it has been updated with the addition of a new Title II, the repeal of the Independent Payment Advisory Board, which was established under the Affordable Care Act. The purpose of updating the bill is for Title I to provide an offset for Title II, but the true purpose is to eliminate bipartisan support of the IPAB repeal while simultaneously ramming through a tort reform bill. Medical malpractice is about real people with real injuries. The Institute of Medicine estimates that 98,000 people die each year in the United States from preventable medical errors. Let me take a second to talk about the loss of a leg. It's impossible to say how much a leg is worth. So what happens is a plaintiff establishes pain and suffering from the loss of that leg, and based on the pain and suffering, the loss of the leg is compensated, and that's up to a jury. Now, other damages that are sought in a medical malpractice case involve economic losses, economic damages. So we got two kinds of damages: non-economic, pain and suffering, economic damages for loss of wages, medical bills, and other expenses. Now, every plaintiff in a medical malpractice case is seeking damages for non-economic losses. If those damages are limited by an arbitrary and capricious cap of $250,000 for pain and suffering, non-economic loss, it's an affront to a person's ability to be able to go to court and get full compensation for the damage that has been caused by someone else's negligence. Now, on the other hand, a high wage earner with a lost leg can get, if it's depending on how much money they make, they can get unlimited damages for their economic loss, for their lost wages, future lost wages. For someone like an elderly person who is not working, someone like a child who has no income, someone like a injured person who has no income, they are going to be limited to the $250,000. I think that this is a grave injustice. Tort reform proposals such as H.R. 5 fail to address the deaths and injuries associated with preventable medical errors every year. H.R. 5 is the wrong way to go. Instead, Congress should focus on improving patient safety and reducing deaths and injuries, not insulating and immunizing negligent providers from accountability, harming patients, and at the same time saddling taxpayers with the costs, as this bill would do. Further, medical malpractice and other areas of tort reform are areas of the law that should be left to the states. In a one-size-fits-all federal policy on state rules regulating the award of damages for compensation for medical malpractice is a one-size-fits-all policy that also misses important factors in particular states and likely would create harmful unintended consequences in state court systems. Now, ever since the Republic was founded, we've had states' rights, and these states' rights have been applied in the area of state laws, state tort laws. Each state has its own set of laws regarding torts, criminal offenses, and the like. For the federal government to come in and immunize doctors and medical providers with a $250,000 cap for non-economic losses is a preemption of the state's right to award more damages for non-economic losses. Now, for instance, take the medical malpractice law in the state of Georgia, which is my home state. In 2010, in Atlanta oculoplastic surgery, PC versus Nesselhunt, the Georgia Supreme Court struck down the state's statutory caps on non-economic damages in medical malpractice cases. The Georgia Supreme Court ruled that limits on damage awards violate the constitutional right to a jury trial. It eliminated unjustified constraints on injured patients' right to seek compensation for pain and suffering caused by the negligence of healthcare professionals who caused them harm. That case involved Betty Nesselhunt, whose 2006 plastic surgery on her face resulted in permanent disfigurement. The jury awarded Nesselhunt $1.265 million, including $900,000 for non-economic damages. The trial court reduced the $900,000 award to comply with the Georgia Tort Reform Act of 2005, which capped non-economic damages at $350,000. On appeal, Nessel Hutt and her husband alleged that the law violated their constitutional right to a jury trial, the Georgia Constitution. Every state has its own constitution. Georgia's jury trial law, right to a jury trial, the court concluded that statutory caps undermine a jury's basic function in tort cases because the limits nullify the jury's findings of fact regarding damages. And so they were thus deprived of their fundamental right under the state constitution to a jury trial. If you are a champion for states' rights, you cannot in good conscience fail to make my states' rights amendment in order. To stay true to the 10th Amendment, I would hope that this committee would make this states' rights amendment in order and allow it to proceed to the House floor for a vote. Thank you, and I yield back the balance of my time.
Thank you very much, Mr. Johnson. Dr. Brown, I think if your colleagues could make a little space for you, or if you want to pull up, there you go.
Thank you, Ms. Fox. I have two amendments that are being considered today. I want to focus on one. It's numbered 12 in the list of amendments. It's been proposed by Mr. Terry, Mr. Johnson of Illinois, myself, and it would simply split the two issues. There are many members on both sides that would like to see us get rid of this onerous IPAB board, which is going to be a rationing board. There are Democrats as well as Republicans that would vote to eliminate IPAB. But if you know these two issues together, we're going to lose a lot of people that on both sides that would vote to eliminate IPAB. And I think from a policy perspective, we've got to get rid of this very onerous part of the Affordable Care Act. I'm not trying to kill Dr. Gingrich's bill. There are a lot of people, many people on the Republican side that would vote for Dr. Gingrich's bill. There may be even some on the Democrat side that would vote for his bill. But when you marry the two, what's going to happen is that we'll have less likelihood to get rid of IPAB, which is going to be disastrous. The Congressional Budget Office, we asked in our office about scoring just doing IPAB. There is some discussion with CBO. They said that IPAB is not going to save any money, but possibly just repealing it would cost a little over $3 billion. I'm not sure if it's not going to save any money, having it in place, that getting rid of it is going to cost that much money. But in fact, Politico ran an article about that just recently, and I would ask unanimous consent to that be included in the record. So there's some room for debate, and I would like to see us split these two, have two votes, one on Dr. Gingrich's bill and one on repealing IPAB, and that's what Amendment 12 does. The other amendment, very quickly, what it does is it helps solve some of the problems that I've heard with other panel, because what it does is it just applies tort reform to any program that is of federal nature, and it doesn't apply to any non-federal program. So I ask that the committee hold both of my amendments in order and would like to see votes on both. Now yield back.
Madam Chair, has everyone had an opportunity to cast their vote on the first?
I don't know that they have, and I was going to ask the members of the committee, would you all I'd like to recognize people to see if they have any questions of Mr. Johnson and Dr. Brown, and if they don't, then they would be allowed to leave. They've both been here for a long time. I'd like to honor their time. Anybody have any questions? Okay. Then if you gentlemen would like to go, you're fine. And it looks like we may not be able to get through each person's comments, so I assume we should then take turns going and voting, because we will have a little bit of time if you want to do that. I don't think we can get through.
We voted.
You voted.
And we won't call for a vote in the Rules Committee.
Rob,
You go vote.
would you like to go vote and then come back and take the chair? Okay. How about that? Yes, Ms. Waters, have you voted? No. Would you like to go vote very quickly? I would recognize Ms. Lee. It's up to you. I'll recognize you now. 0 minutes.
Maybe over, Max. And there's 10 more minutes of debate after this, but you should go vote.
Okay. Ms. Lee?
Thank you. I voted. Thank you very much. To the Rules Committee, thank you very much. And I thank you for considering my amendment. The amendment will exempt victims of malpractice that resulted in irreversible injury, including loss of limbs and loss of reproductive ability from the $250,000 cap that H.R. 5 imposes on non-economic damages. We have seen this initiative in 2005 as written in the Health Act. We also see the damage that this kind of amendment brings about. Frankly, I do think that the discussion that the first panel had was not truly answered. This is taking over state law. The bill is so broadly drafted that it would also limit remedies against the for-profit nursing home, insurance, and pharmaceutical industries, and even against doctors who have committed intentional torts such as sexual abuse. There are a number of reasons why this bill is flawed. Its scope is extremely broad and encompasses much more than necessary to simply protect doctors from high insurance premiums. It contains a sweeping preemption of state law. It reduces the statute of limitations on malpractice claims. It severely restricts contingency fees, discouraging lawyers from taking on vital cases. According to a 2010 study by the Office of Inspector General of the U.S. Department of Health and Human Services, about 1 in 7 patients experience medical error, 44% of them which are preventable. So my amendment seeks to ensure that the healthcare services or medical products are not under this provision if such provision, use, or failure results in irreversible or life-altering injury, including loss of limb or the loss of reproductive capacity. Just allow me to give you a brief story of a woman by the name of Connie Spears in Texas, where as a patient, she had dealt with blood clots in the past and had a filter installed in one of her heart's main arteries. Ms. Spears went into a San Antonio hospital complaining of leg pain. She was made to wait, eventually treated, and was discharged. However, 3 days later, when her legs were the color of carbonate, she was delirious. She called 911. When Spears, who was rendered unconscious, was treated at a different hospital, they determined that the filter in her artery was severely clotted and had caused tissue death in her legs as well as kidney failure. Weeks later, Connie Spears regained consciousness and learned that doctors had to amputate not one but both of her legs in order to save her life. As a result of the negligence by the emergency room doctors who initially treated Ms. Spears, she lost her legs and nearly her life. This broad-based bill is an intrusion on state law, and if I might ask unanimous consent, Madam Chair, to submit into the record a letter from the American Bar Association. And let me briefly, I will not read it in its entirety, just say that they are troubled and bothered by and impose this provision, Title I of H.R. 5. It would cap the non-economic damages that a plaintiff in a healthcare lawsuit will recover. It would also pre-exempt existing state laws on proportionate liability, allow courts to reduce contingent fees, and abolish the collateral source rule. For over 200 years, the authority to determine these matters and other aspects of medical liability has rested with the states. This system, which allows each state the autonomy to regulate the resolution of medical liability actions within its borders, is a hallmark of the American justice system. I would ask the Rules Committee to consider my meager attempts to comply with 200 years of jurisprudence. Judge Hastings, I think you've seen these cases as well. 200 years of jurisprudence to narrow the federal intrusion on this kind of relief, and particularly to ensure that individuals who have suffered both loss of limb, life-altering injury, and damage to their reproductive capacity should be allowed to be exempted from this law. And I ask my colleague, ask the Rules Committee to support this amendment. And thank you very much.
Thank you. Ms. Jackson-Lee, have you already voted on this amendment? Okay. Ms. Wasserman-Schultz, you're recognized.
Thank you, Mr. Chairman.
pediatrician after discovering videotapes in his residence that showed him raping or sexually abusing over 100 children between 1998 and 2010. Many of these children appeared to lose consciousness during these sexual assaults that he recorded on video. One Delaware mother, who had sent both of her daughters to Dr. Bradley, really put it best. She said that our worst fears have been realized. He's just pure evil. No one with a conscience could do this. And she's right. But many of these victims had their cases thrown out of court because up until that point, Delaware had a restrictive statute of limitations similar to the statute of limitations in the so-called Health Act that we're considering here. Now, their cases had been thrown out because too much time had elapsed between the offense and the lawsuit, even though many of these victims were unconscious when this happened. We can't go down that road. As I said before, restricting the rights of children will not reduce the number of frivolous lawsuits. It merely limits the rights of children who are suffering due to preventable medical errors or intentional assaults, like the 10-year-old who develops HIV, or the 103 little girls in Delaware who may not even have been aware that they were being assaulted by their trusted pediatrician. Let's not go down the road that Delaware did, only to realize that we have a moral obligation to turn back. Again, the best way to cut down on malpractice lawsuits is to improve patient safety and care, not arbitrarily limit the rights of those who have been injured. Thank you, Madam Chair.
Mr. Deutsch?
Thank you, Madam Chair. Today I offer an amendment that is extremely straightforward. My amendment ensures that doctors who intentionally, not accidentally, but intentionally harm their patients are not exempt from medical malpractice liability. Such instances may be rare, but that does not mean our justice system should treat them leniently. It is no secret that I fundamentally disagree with the premise of this legislation. Arbitrary limits on claims made by patients have never been proven to solve the very problem we seek to address, which is the cost of medical malpractice awards. And the Bill of Rights includes 10 amendments, each of them important. This legislation tramples on the right to a jury trial enshrined in the 7th Amendment. If we're going to go down this path, however, the very least we can do is ensure that doctors who intentionally abuse their patients do not evade justice. If the majority in this House of Representatives wants to tell a child who is made blind through the negligence of his doctor that we know better than a jury, I disagree, but so be it. Surely the sponsors of this legislation do not intend...
Ms. Wasserman Schultz, we can't deny any member the opportunity to ask a question of you, and so when he's complete with his testimony, thank you.
Surely the sponsors of this legislation do not intend to extend their liability caps to a pediatrician who sexually abused a child or a dentist who raped a patient under sedation. I'm disgusted to say those are both the real examples of the kind of abhorrent behavior we would be mistakenly immunizing if we fail to adopt my amendment. Regardless of your position on medical malpractice reform, there are liability protections within H.R. 5 that have absolutely no business in this bill. There is just no reason to preempt state law to protect medical professionals that intentionally harm patients. Now I understand there's been a procedural objection raised to my amendment that somehow, even though no one will actually run the numbers or show me any real calculations that have been made, this amendment is supposedly in violation of Cutco. Let's think about that for a moment. This amendment does not create some big government regulations or set aside money for any program. It says that in the rare but horrific event that some doctor abuses his patient, then we are not going to offer that doctor special protection from lawsuits. And let's remember that this amendment does not create a new avenue for litigation or add to the burden of courts in any way. No cost there. I would love for someone to explain to me how this amendment costs even 1 penny. Better yet, I'd like for someone to explain to the 103 children who were molested by the Delaware pediatrician that the United States Congress wants to make it easier for that pervert to evade justice. Because the only way that preserving the rights of a victim of assault will cost a penny is if there is an assault in the first place. Are we really going to go down that road? What's next? Are we going to stop criminal prosecutions of murderers because it is just too expensive to prosecute? It doesn't have to be this way. My amendment would exempt intentional acts from the scope of the bill's coverage for a specific, limited list of acts. If we adopt my amendment, individuals who commit the following heinous intentional acts would not be shielded from liability: conversion, false imprisonment, intentional infliction of emotional distress, fraud, misrepresentation, malicious prosecution, abuse of process, invasion of privacy, slander, libel, defamation, assault, battery, or rape. Differentiating between medical errors and intentional harm is not a creative new idea. Many states with limits on medical malpractice already make a distinction for intentional torts. In fact, in the state of Georgia, H.R. 5 would preempt that distinction and offer liability protection for doctors who rape and abuse their patients. If the majority is set on passing this bill, we can still correct this overbroad language and preserve the numerous good state laws already on the books. During being in the Judiciary Committee, I heard this amendment is unnecessary because even in the absence of criminal activity, cases involving intentional torts are not protected under this bill because they are extreme and non-therapeutic in nature, therefore don't meet the definition of a health care good or service. At best, the language in the bill is unclear, but my fear is that H.R. 5 would provide protection for these intentional torts, and it's not unfounded. Except in those instances in which a claim is based upon criminal liability, H.R. 5 extends its liability protections to those who have committed these and similar kinds of acts, including conduct that results in egregious injury or even death to patients. This amendment makes a terrible bill slightly better. This bill still violates the Seventh Amendment rights of Americans by assigning arbitrary caps on damages for those who have suffered the worst imaginable injuries. But at least we can preserve the rights of victims of assault, of battery, and of rape. I ask the committee not to hide behind a completely baseless claim of cut-go violations and allow the full House to hear and consider my amendment. Any illusory savings that keep this amendment off the House floor will prevent victims of horrific offenses from exercising their constitutional rights. I ask this amendment be ruled in order, and I yield back the remainder of my time.
Thank you very much. Ms. Waters.
Thank you. Thank you very much. I'd like to thank you, Chairman Dreyer and Ranking Member Louise Slaughter, and all the members of the committee for allowing me to testify today. I'm here to request that the Rules Committee waive all points of order and allow me to offer an amendment with Representative Conyers. It is known as the HELP to H.R. 5, the HELP Accessible, Efficient, Low-Cost, Timely Health Care Act. Our amendment, the Conyers Waters Amendment to H.R. 5, will repeal certain provisions in the McCarran-Ferguson Act, which currently exempt medical malpractice insurers from federal antitrust laws. Mr. Chairman, it's time. It's time. This has been tried many times before. This amendment would subject medical malpractice insurers to the same good competition laws that apply to virtually every other company doing business in the United States. Consumers would benefit through lower prices, more choices, and better services. Doctors and healthcare providers would benefit from this increased competition because it would mean lower costs and greater availability of medical malpractice insurance. In the past, insurance companies paying out due to catastrophic incident have cut their medical malpractice insurance lines because they have the least potential for growth. When these large insurance carriers cut their medical malpractice lines, there is an availability crisis because there are relatively few insurers that will carry it due to the limited growth potential. When profitability is good, insurers actively compete by lowering rates and expanding coverage in order to increase premium and investment income or retain market share. But in economic downturns, when profits may decrease, the antitrust exemption allows insurers to collectively raise premiums without fear of prosecution. Legal challenges involving alleged price fixing by insurers are typically dismissed by the courts because of the industry's special exemption from the antitrust laws. The conclusion of much of the empirical research is that even if tort reform saves insurance companies money, those savings are not passed on in the form of lower physician premiums or health care costs. A study of the leading medical malpractice insurance companies' financial statements by former insurance Commissioner Jay Angoff found that these insurers artificially raised doctors' premiums and misled the public about the nature of medical negligence claims. These rapid increases in premiums have led to one thing for insurance companies: massive profits. In 2008, the average profit of the 10 largest medical malpractice insurers in the U.S. was higher than 99% of Fortune 500 companies and 35% times higher than the Fortune 500 average for the same time period. In fact, this may actually understate insurance industry profitability, given the medical malpractice insurance industry's practice of systematically overestimating their losses and underestimating their profits. Revised statements of actual losses typically show that insurers reap more profits than they initially reported. We need to hold medical malpractice insurers accountable for their anti-competitive practices that have contributed to skyrocketing health care costs. It is unconscionable for us to keep passing legislation that severely limits patients' rights while malpractice insurers continue to benefit from the McCarran-Ferguson Act. I thank the Rules Committee for considering the amendment.
Mr. Gosar.
And thank you very much.
And then we'll quickly go to questions. I know Ms. Westman is ready to do so. As quickly as we can.
Chairman Dreyer and Ranking Member Slaughter, thank you for the opportunity to offer this amendment today. This amendment is formatted from the text of H.R. 1150, the Competitive Health Insurance Reform Act. H.R. 1150 would amend the McCarran-Ferguson Act so that the health insurers would be required to abide by many of the antitrust laws that most businesses and industries do today. I believe that the Rules Committee has a duty to rule this amendment in order today. I support the underlying bill, H.R. 5, in part because it will lower the cost of medical malpractice premiums for the medical providers. In turn, H.R. 1150 is an appropriate amendment because it intends to lower the cost of health insurance for consumers. I would also point out that page 18 of the committee print of H.R. 5 addresses the issue of antitrust lawsuits. My amendment amends federal code with respect to antitrust law, and so I believe this amendment must be given an opportunity for debate on the floor. This proposal is a classic example of true health care reform that will bring down the cost of health insurance, and all it will take is for this committee and the House to repeal an outdated, nonsensical carve-out for the health insurance industry. I now have no factual basis to continue this exemption, and I believe that repealing it will lower the cost of health insurance. That should be a goal that every member of this body shares. In fact, this proposal is highly similar to H.R. 4626, which passed the House by an overwhelming vote of 406 to 19 when it was offered in February 2010. Every single one of you ladies and gentlemen that were serving in Congress at the time supported this legislation. I know that Ms. Slaughter has also been a champion of this issue and have offered her own similar proposal. Thanks in advance for your time, and I look forward to working with you on this issue.
Thanks very much. Any questions for the panel? Ms. Fox? Slaughter?
It's medical insurance.
Bishop? Mr. Hastings? Mr. Nugent? Mr. Polis? Thank you all very much.
Mr. Chairman, I just want to indicate that my amendment is supported by Mr. Hank Johnson and Mr. Quigley of the Judiciary Committee, so Jackson, Lee, Johnson, Quigley amendment. And I also ask for the waivers be in place to make it in order. Thank you.
Thank you very much. That will conclude the hearing, and we will rule.
This is the letter. This is the
The chair will be in receipt of a motion.
Thank you, Mr. Chairman. I move the committee grant H.R. 5, the Help Efficient, Accessible, Low-Cost, Timely Health Act of 2011, a structured rule. The rule provides 6 hours of general debate, equally divided among and controlled by the respective chairs and ranking minority members of the committees on Energy and Commerce, the Judiciary, and Ways and Means. The rule waives all points of order against consideration of the bill. The rule provides an amendment in the nature of substitute consisting of the text of Rules Committee Print 112-18 shall be considered as adopted, and the bill as amended shall be considered as original text for the purpose of amendment and shall be considered as read. The rule waives all points of order against provisions in the bill as amended. The rule makes in order only those further amendments printed in the Rules Committee report. Each such amendment may be offered only in the order printed in the report, may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and an opponent, shall not be subject to amendment, and shall not be subject to a demand for division of the question. The rule waives all points of order against the amendments printed in the report. Finally, the rule provides one motion to recommit with or without instructions.
You've heard the motion of the gentlewoman from Grandfather Community to discuss your amendment. Ms. Slaughter.
Thank you, Mr. Chairman. I have an amendment to the rule. I move the committee grant H.R. 5 an open rule so that all members have the opportunity to offer amendments to the bill on the floor.
You've heard the motion of the gentlewoman. For the discussion, if not, vote occurs on the Slaughter amendment. Those in favor say aye.
Aye.
Opposed, no.
Roll call, please.
Mr. Sessions. Ms. Fox. Mr. Bishop. Mr. Woodall.
Mr. Nugent. Mr. Scott. Mr. Webster. Ms. Slaughter.
Aye.
Mr. McGovern.
Aye.
Mr. Hastings. Mr. Hastings votes aye. Mr. Polis.
Aye.
Mr. Polis votes aye. Mr. Chairman.
No.
Chairman votes aye.
I vote no.
I vote no.
The clerk report the total.
3 yea, 6 nay.
Should be 4 A's, I think.
Sorry. Let me revise that. Yes.
Why don't we just call the roll again?
It's, Mr. McGovern was not recorded.
Oh, I thought you voted? I thought he did, aye.
Mr. McGovern is recorded as an aye. 4 yea, 6 nay.
Yes, Mr. Chairman. Mr. Chairman, I have an amendment and a very quick statement. Mr. Chairman, I have an amendment to the rule. Move the committee make an order and give the necessary waivers for the amendment by Mr. Johnson of Georgia, Mr. Braley, and Mr. Nadler on number 6, which would simply specify that nothing in this bill preempts any applicable state constitutional provision, and the amendment by Mr. Pohl, number 7, which would prevent the bill from preempting any state law already on the books. Mr. Chairman, earlier I made comments regarding the 10th Amendment, and I can alert our colleagues that I intend to make much of that tomorrow during the period of the rule. I'm really surprised that my Republican colleagues are pushing a bill that strips the states of their traditional jurisdiction over legal disputes and mandates a federal takeover of these state prerogatives. So I urge my colleagues to support this amendment to the rules so that the House can vote on this question directly.
Vote occurs on the Hastings Amendment. Those in favor will say aye.
Aye.
Those no. No.
I ask for a roll call, Mr. Chairman.
Mr. Sessions. Ms. Fox. No. Ms. Fox votes no. Mr. Bishop. Mr. Bishop votes no. Mr. Woodall. No. Mr. Woodall votes no. Mr. Nugent. Mr. Nugent votes no. Mr. Scott. Mr. Scott votes no. Mr. Webster. Mr. Webster votes no. Ms. Slaughter.
Aye.
Slaughter votes aye. Mr. McGovern.
Aye.
Mr. McGovern votes aye. Mr. Hastings.
Aye.
Mr. Hastings votes aye. Mr. Polis.
Aye.
Mr. Polis votes aye. Mr. Chairman.
No.
Chairman votes no.
The clerk will report the total.
4 yea, 7
The
nay.
amendment is not agreed to. There further amendments? If not, I'm sorry, Ms.
Thank
Slaughter,
you.
I'm sorry.
I do have further amendment.
Yes, ma'am.
Move the committee make an order and give the necessary waivers for the amendment by Representative DeGette, number 19, which would deny the protections from a health care liability claim against a health care organization in the underlying bill to the extent that such claim is based on an act or omission constituting a violation of the Patient Protection and Affordable Care Act. The reason I'm bringing this up, Mr. Chair, is that this amendment that Ms. DeGette brought for us does not violate PAYGO and conforms with all the germaneous rules. We were wondering why it was left out.
Well, we appreciate that. Obviously, we're making as many amendments in order as we possibly can, and we're just not making this amendment in order if the committee will support the position that we've reported out.
Uh-huh. Well, we'll try to explain that to Ms. DeGette.
Okay. Vote occurs on the Slaughter amendment. Those in favor will say aye. Those opposed, no. No. The paying the chair
Roll
knows
call,
have it.
please.
Clerk, call the roll.
Mr. Sessions. Ms. Fox.
No.
Ms. Fox votes no. Mr. Bishop. Mr. Bishop votes no. Mr. Woodall.
No.
Mr. Woodall votes no. Mr. Nugent. Mr. Nugent votes no. Mr. Scott. Mr. Scott votes no. Mr. Webster. Mr. Webster votes no. Ms. Slaughter.
Aye.
Slaughter votes aye. Mr. McGovern.
Aye.
Mr. McGovern votes aye. Mr. Hastings.
Aye.
Mr. Hastings votes aye. Mr. Polis.
Aye.
Mr. Polis votes aye. Mr. Chairman.
No.
Chairman votes no.
And the clerk will report the total.
4 yea, 7 nay.
And the amendment is not agreed to. There further amendments? Mr. Woodall.
Mr. Chairman, I move that my amendment be modified to strike all the findings in Section A.
All of the findings in Section 8.
Subsection A, I'm
Yes,
sorry. A.
subsection A?
A.
Right. I know this deals with the state's rights issue. Vote occurs on the Woodall amendment. Those in favor will say aye. Those
Aye.
opposed, no. Paying the chair, the ayes have it. The ayes have it. The amendment is agreed to. Are there further amendments? If not, the vote occurs on the motion of the gentlewoman from Grand Feather Committee. Those in favor will say aye.
Aye.
Those opposed, no.
No.
Paying the chair, the ayes have it. The ayes have it. The
Roll
motion is
call,
agreed to.
please.
Clerk, call the roll.
Mr. Sessions. Ms. Fox.
Aye.
Ms. Fox votes aye. Mr. Bishop. Mr. Bishop votes aye. Mr. Woodall. Mr. Woodall votes aye. Mr. Nugent. Mr. Nugent votes aye. Mr. Scott? Mr. Scott votes aye. Mr. Webster? Mr. Webster votes aye. Ms. Slaughter?
No.
Ms. Slaughter votes no. Mr. McGovern?
No.
Mr. McGovern votes no. Mr. Hastings?
I'm only hesitant for the reason I'm trying to figure
What it was.
Anyway, I vote.
Mr. Hastings votes no. Mr. Polis? Mr. Polis votes no. Mr. Chairman?
Aye.
Chairman votes aye.
Clerk report the total.
7 yea, 4 nay.
And the motion is agreed to, and this will be managed for the majority by Mr. Nugent
Mr. Hastings.
and Mr. Hastings for the minority. Thank you all very much. That should complete our action for the week. Without objection, the committee stands adjourned.